Imagine a courtroom, the air thick with anticipation. A judge presides from a high bench, a prosecutor lays out his case, and a defense attorney prepares a rebuttal. In the dock, awaiting judgment, sits the accused. A pig. This isn't a scene from a fantasy novel. For centuries, this was a genuine and shockingly common legal reality in medieval Europe. Welcome to 10-Minute History. I'm your host, Jake Sullivan, and today we're diving deep into the strange world of animal trials, where pigs were hanged, rats were sued, and roosters were burned at the stake. From the 9th to the 19th century, court records show that all sorts of creatures were arrested, imprisoned, and formally tried in court. If found guilty, they were publicly executed, just like human criminals. But this wasn't just limited to individual animals. Entire species of pests, like rats, locusts, and caterpillars, were summoned to church courts, assigned their own defense lawyers, and faced sentences of excommunication if they didn't stop destroying crops. The big question isn't just that these trials happened, but why? What possessed a community to dress a pig in human clothing for its execution? What do these elaborate, serious, and expensive legal rituals reveal about the world our ancestors lived in? It turns out these trials weren't just acts of superstitious madness. They were a sophisticated way for people to restore social and cosmic order in a world that often felt chaotic and terrifying. So how could a society possibly justify putting an animal on trial? The answer lies in a worldview that was totally different from our own, built on two powerful ideas. The first and most important justification came straight from the Bible. Medieval lawyers pointed to a specific passage in the book of Exodus, which laid out the law of the goring ox. The rule states, and I quote, "If an ox gores a man or a woman to death, the ox shall be stoned." To a medieval jurist, this was an unambiguous divine command. It established that the animal itself was culpable, that it had to pay for its crime. The command to stone the ox was also significant. Stoning was reserved for grievous sins that polluted the whole community, like blasphemy. So this elevated the ox's crime from a simple accident to a defiling act that required a community-wide ritual purging. They also pointed to a passage in Genesis where God, after the Great Flood, says he will require a reckoning for human life from every beast. In their eyes, when a court prosecuted an animal for murder, it was simply acting as God's agent on earth, carrying out a divinely ordered duty. The second big idea was something called the Great Chain of Being. People in the Middle Ages saw the entire universe as a rigid, divinely ordered hierarchy. God was at the very top, followed by angels, then humanity, then animals, then plants, and finally minerals at the bottom. Everything had its proper place. So when an animal killed a human, it was a profound violation of this natural order. It was an act of rebellion, a lower being harming a higher one. The legal trial and the public execution were a ritualistic way of putting things back in their proper place, of mending a tear in the very fabric of the cosmos. This worldview led to two different kinds of animal trials, run by two different court systems. First, you had the secular courts, run by lords or city magistrates. These courts handled capital crimes, like murder. When a domestic animal like a pig, bull, or horse killed a person, it was arrested, often kept in the local jail next to human prisoners, and put on trial. If found guilty, it was sentenced to death, usually by hanging. Second, you had the ecclesiastical or church courts. They stepped in when the problem wasn't a single animal, but a collective swarm of pests, like rats or insects, that were destroying crops. You can't arrest 1,000,000 caterpillars, so the church developed a different legal process. They would formally summon the pests to court, appoint a lawyer to represent them, and if the pests were found guilty of damaging the community's livelihood, the bishop would formally excommunicate them, cursing them in the name of God and ordering them to leave. Now let's get into the most incredible cases, because this is where history gets truly bizarre. Perhaps the most famous animal trial of all is that of a sow in the town of Falaise, France, in 1386. In the town square, a pig attacked a 3-month-old infant, mauling the baby's face and arms so severely that the child died. The community was horrified, and the wheels of justice turned swiftly. The pig was arrested by officers of the law and thrown in the town jail, with the state paying for its room and board. A full trial was held, witnesses testified, and the sow was found guilty of murder. The judge ordered that the pig be maimed in its head and forelegs to mirror the injuries of the child it killed, and then hanged. But the execution is what makes this case legendary. It was a massive public spectacle. In a moment of stunning symbolism, the condemned sow was dressed in human clothing. It was fitted with a man's waistcoat, pants, and even gloves on its front hooves. This visually transformed the pig from a simple animal into a humanoid criminal, a felon being brought to justice. Farmers from the countryside were told to bring their own pigs to the square to witness the execution, as a warning. And we know all of this happened because the executioner's meticulous expense report survived. It lists the costs for the pig's food in jail, the executioner's fee, the cart that carried the sow to the gallows, and even a charge for a new glove so the executioner's hands wouldn't be soiled. This wasn't a joke, it was a formal, state-funded legal procedure. While pigs were tried for murder, other animals were prosecuted for what were seen as crimes against nature. The best example is the trial of a rooster in Basel, Switzerland in 1474. The rooster's crime? It was accused of laying an egg. This wasn't seen as a biological fluke. It was seen as a work of the devil. There was a widespread belief that an egg laid by a rooster would hatch a mythical monster called a basilisk, a serpent-headed creature that could kill a man with a single glance. So a cock's egg was a sign of immense danger. The city magistrates took this with the utmost seriousness. The rooster was arrested and put on trial. The court even appointed a defense lawyer for the rooster, an attorney named Jacob Hertz. The prosecutor argued the rooster was a demon in disguise. The defense lawyer argued that his client couldn't form a guilty mind, that it was just an involuntary act of nature. The court wasn't convinced. They declared the rooster guilty, a vessel for the devil, and sentenced it to death by fire. Burning at the stake was a punishment reserved for the worst crimes against God, like heresy and witchcraft. So the rooster and its offending egg were publicly burned to purify the community of this demonic threat. And what about those church trials against pests? One of the most celebrated cases involved the rats of Autun, France, around 1510. The local farmers sued the rat population for destroying their barley crops. When the rats failed to appear in court, a brilliant young lawyer named Bartholomew Chassigny was appointed to be their defense attorney. Chassigny didn't deny that the rats were eating the barley. Instead, he used the court's own rules to tie it in knots with a series of ingenious procedural delays. First, he argued that the court summons wasn't valid because it was only announced in the town of Autun. He claimed his clients were scattered across the entire region and they all needed to be properly notified. The court agreed and ordered the summons to be read in every church in the diocese. When the rats still didn't show up, Chassigny argued that his clients, many of whom were infants, or aged, or sick, hadn't been given enough time to make the long journey to the courthouse. The court again agreed and granted a postponement. Finally, Chassigny unveiled his masterpiece argument. He admitted his clients had been properly summoned and given enough time. However, he said, they couldn't possibly obey the court's order because they were in mortal danger. The villagers who were suing them owned a great many cats who had murderous intentions. He argued that his clients couldn't safely travel to the courthouse without running a deadly gauntlet of feline predators. Therefore, he formally requested that the court order the villagers to post a bond, a large sum of money to be forfeited, if any of their cats harmed any of his rat clients on their way to trial. The court was thrown into confusion. The case was postponed, and Chassigny became a legal star. So why did this all stop? The practice of animal trials faded away in the 17th and 18th centuries, largely thanks to a profound shift in thinking driven by the scientific revolution. The French philosopher René Descartes was a key figure. He famously argued that animals were just complex machines, like intricate clocks. He called them beast machines incapable of thought, feeling, or forming a guilty mind. If a pig that kills a child is no more guilty than a roof tile that falls on a pedestrian, then you can't put it on trial. Responsibility shifts from the animal to its owner. and this new way of thinking changed the law. Animals were reclassified purely as property, and the owner became legally liable for any damage their property caused. But the echoes of these trials are still with us today. Think about modern dangerous dog laws. When a dog attacks a person, it's seized by animal control, which is a modern form of arrest. It undergoes a behavioral assessment, and if deemed vicious, it's often put down by order of the state. The gallows has been replaced by a veterinarian's syringe, but the core action is the same. The state is still exercising the power of life and death over an animal because of the harm it caused. And the bigger debate is far from over. In 2015, France officially changed its legal code to recognize animals not as property, but as living beings endowed with sensitivity. Legal groups today are even filing lawsuits arguing that intelligent animals like chimpanzees should be recognized as legal persons with basic rights. These are the direct descendants of the medieval debate, asking the same fundamental question: must the legal community be exclusively human? In the end, the history of animal trials teaches us that these were not just bizarre superstitious acts. They were a powerful tool for communities to make sense of tragedy, to manage their collective trauma, and to restore a sense of order in a chaotic world. They show us a time when the universe was seen as a single moral stage, where every creature, great and small, had a part to play. The sow in the dock stands as a strange and powerful monument, marking the beginning of a conversation about justice and our relationship with the animal world that we are still having today. So what are your thoughts on this? Let us know down in the comments. If you found this interesting or learned something new, please give this video a like, and don't forget to subscribe to 10-Minute History for more deep dives. Thanks for listening.